We, the people.
Of the United States.
In order to form a more perfect union.
Establish justice.
Ensure domestic tranquility.
Provide for the common defense.
Promote the general welfare.
And secure the blessings of liberty.
To ourselves and our posterity.
Do ordain and establish.
This Constitution.
For the United States of America.
Hi, everybody. I want to welcome you to today's Constitution Day keynote. I'm Matt Auer. I'm the Dean of the School of Public and International Affairs at the University of Georgia. The U.S. Constitution was signed on this day 233 years ago on September 17, 1787. The celebration of the U.S. Constitution goes back to 1940, when America observed I Am an American Day and later Citizenship Day. Constitution Day was recognized as a federal holiday in 2004 when Senator Robert Byrd presented a bill designating September 17th as the day for citizens to remember and honor the signing of the U.S. Constitution. Today's event couldn't have taken place without the generous support of several organizations, both on and off UGA's campus. Among the sponsors are the School of Public and International Affairs, the American Founding Group, the Wilson Center for Humanities and the Arts, and the Jack Miller Center. A special thank you to Caroline Pachkowski, Lauren Ledbetter, and Keith Doherty from SPIA for help organizing today's event. I want to give everybody just a couple of quick pointers for our webinar. Our speaker will share his remarks, and as that's taking place, we welcome questions. Please use the question and answer feature in Zoom. The chat is disabled, so use the Q&A function that's in the bottom of your tray. My colleague, Professor Keith Doherty, will share your questions with our keynote speaker after his prepared remarks. It's a pleasure and honor to introduce our keynote speaker, Dr. Michael Zuckert, who is the Nancy R. Dreux Professor Emeritus of Political Science at the University of Notre Dame. Professor Zuckert is a polymath, a scientist and a humanist. Books that he has authored range from a co-authored work with Catherine Zuckert on political theorist Leo Strauss to other landmark work on political theory and constitutional studies. The journal he founded, American Political Thought, bridges the gap between historical, empirical, and theoretical research on American political ideas, institutions, and culture. He co-authored and co-produced a public radio series, Mr. Adams and Mr. Jefferson, a 9-part drama for the radio. He was also Senior Scholar for Liberty, a 6-hour public television series on the American Revolution. And he served as senior advisor on the PBS series on Benjamin Franklin and also on Alexander Hamilton. It's a pleasure to welcome Professor Michael Zuckert as our 2020 Constitution Day speaker. Welcome, Professor Zuckert.
Thank you, Dean Auer, for that generous introduction. And thanks also to Professor Doherty for inviting me to Georgia. I always enjoy coming to Georgia, especially on cool, overcast days like today in Chicago. And I'd like to add greetings to all of you in the audience who I cannot see at all, but I trust that you're there. At least I have some electronic indication that you're there. So as Dean Auer just indicated, today is Constitution Day, and that is the anniversary of the day on which the delegates to the Constitutional Convention signed that document. And as he said, Congress set this day aside in order to celebrate the Constitution. Now, I want to do my part in doing so by saying just a bit about the Bill of Rights. The Bill of Rights is that part of the Constitution that polls of the American people regularly show to be the most admired and the most valued part of the Constitution. Now, given that fact, it may perhaps seem strange to you that the Bill of Rights almost did not make it into the Constitution. It is fairly widely known that on September 17, 1787, when the delegates signed the draft Constitution, there was no Bill of Rights in it. Now, why that was so has been the subject of much speculation over the years. Now, perhaps the simplest explanation is that the delegates just ran out of time. They had been working since mid-May during a very hot Philadelphia summer with the windows of Independence Hall boarded up so that passersby could not eavesdrop on their conversations. When we think back to their accomplishments that summer, we need to appreciate how much they sweated on behalf of their countrymen and their posterity. Now, a few days before they were to adjourn, one of the delegates said, wait, we have forgotten a Bill of Rights. So when put to a vote, the idea of staying on to prepare a Bill of Rights lost by a vote of 10 states to 0. Let us just say they were eager to get home and to take a shower. But as you might have heard, during the efforts to win approval of the draft Constitution in the 13 states, the absence of a Bill of Rights was raised as a major objection in the state ratifying conventions. Many of the supporters of the Constitution feared that this agitation for a Bill of Rights would sabotage the Constitution, either directly by leading to a vote against it or indirectly by leading to a new convention that would deadlock over the terms of amendments. So a compromise solution was worked out. The state conventions could ratify the draft Constitution as it was, but they could submit proposals for amendments to be considered promptly when the new government started up. A good solution. However, when the new government got going, there was much urgent business to be done. The revenue system, establishing the executive departments, initiating the judiciary, among others, these all needed to be done right away. But after about a year, James Madison attempted to turn the attention of Congress toward this promised Bill of Rights. But at this point, something strange occurred. There was no push to take up amendments. Indeed, there was a good deal of pushback to turning in that direction. Since the Federalists, that is, those who had supported the Constitution, supported ratifying the Constitution, had never been particularly enthusiastic about the Bill of Rights, the lack of interest in that group was not too surprising, except for the fact that they had tacitly promised during the ratifying process to promptly take up amendments. More surprising, however, was the reluctance of congressional anti-federalists to take up amendments. The anti-federalists were those who cried out most loudly against the proposed Constitution because of its lack of a Bill of Rights. So, at this moment, neither the Federalists nor the anti-federalists were at all eager to add a Bill of Rights to the Constitution. The only person who seemed eager to add a Bill of Rights was James Madison. And he had been opposed to a Bill of Rights during the ratification struggle, and afterward was at first lukewarm at best. As he wrote to his neighbor Thomas Jefferson, he claimed, untruly, to have favored a Bill of Rights always. But despite that, he told Jefferson, he never thought the omission a material defect. He added that he had not viewed a Bill of Rights in an important light. Now, this letter to Jefferson was written almost exactly 1 year after the original Constitution Day, that letter being October 17, 1788. About 8 months after that, in June of 1789, Madison rose in Congress to advocate for amendments. At the moment he did that, he was about the only person in government who seemed actually to favor adding a Bill of Rights. Now, while this sort of hypothetical history is always risky, it appears that if Madison had not promoted a Bill of Rights as vigorously as he did, we might not have had this favorite part of the Constitution added to it. So if not for James Madison, perhaps there would be no Bill of Rights. Now, Madison's stance toward a Bill of Rights seemed to have gone through 3 phases: an opposition phase, a lukewarm phase, and then a strong advocacy phase. His first phase, the opposition phase, occupied the time during which the Constitution was being ratified, roughly from, say, September 1787 to June of 1788. He was most outspoken against amendments in the Virginia Ratifying Convention, to which he was a delegate. At that convention, he was quite emphatic. The Constitution, he said, in its present form, is infinitely more safe than it would be after introducing into it that long train of alterations which its opponents call amendments. So on the issue of amendments, however, there were two complicating factors that had much to do with Madison's stridently negative stance in this ratifying convention. First was the issue of timing. As I said before, one of the major themes of anti-federalist opposition to the Constitution was its lack of a Bill of Rights, and that being a concern shared by many citizens who otherwise favored the Constitution. The anti-federalists, used these misgivings to press for amendments prior to ratification. As Madison charged at the Virginia Convention, though, previous amendments are but another name for rejection. Now, Madison addressed these efforts at prior modification of the Constitution in an obscure Federalist paper, hardly ever read anymore, paper number 38. The point of this essay was to face squarely the wide range of objections raised against the draft of the Constitution and to discourage the movement in favor of prior amendments. The objectors, Madison pointed out, do not agree at all on what is objectionable in the Constitution, nor do they agree on what should be done to improve it. Given these disagreements, he insisted that he could, as he put it, never consent to previous amendments because they are pregnant with dreadful dangers. The demand for prior amendments would prevent ratification, he feared, because of the immense disagreements on what to change, that these would prevent consensus on what changes to make. Madison's tactical sense told him that the true friends of the Constitution should give no countenance to prior amendments. So he never spoke out before ratification in favor of a Bill of Rights or any other changes. He explained his strategy clearly to a neighbor. While the Constitution remained unratified, and it was necessary to unite the states in some one plan, I opposed all previous alterations as calculated to throw the states into dangerous contentions and to furnish the secret enemies of the Union with an opportunity of promoting its dissolution. But, he went on, circumstances are now changed. The Constitution is established. Amendments pursued with a proper modification are in the proper moderation and the proper mode will not only be safe, but they may serve a double purpose of satisfying the minds of well-meaning opponents and of providing additional grounds in favor of liberty. Madison's early opposition to amendments had another basis as well. The absence of a Bill of Rights was surely one of the anti-federalists' chief targets in their fusillade of criticisms against the proposed Constitution, but there were many other features of that document to which they objected. Both they and Madison saw many of these to be more important than the Bill of Rights. For example, the Massachusetts Ratifying Convention, which was the first to attach recommended amendments, called for many changes that eventually became part of the Bill of Rights, but also for many structural changes, such as a prohibition on Congress laying direct taxes, on Congress creating monopolies, or regulating elections. As scholar Herbert Storing, a great scholar of the Anti-Federalists, summarized the matter, the Anti-Federalists wanted to revise the basic structure and powers of the new federal government. All the state ratifying conventions that proposed amendments included suggestions to strengthen the states and limit the powers of Congress relating to such crucial matters as federal elections, military affairs, and commercial regulation. Madison, story goes on, made clear that he had no intention of proposing or accepting any amendments along those lines. Well, as it turned out, these dangerous amendments were not seriously considered because of the overwhelming Federalist Party, the supporters of the Constitution, their overwhelming majority in the first Congress. But in the early days of agitation for amendments, Madison had no way of knowing that the process would work in his favor to that decisive a degree. He naturally feared that opening things up to amendments of a Bill of Rights sort could lead to amendments of this other sort that he had no idea of supporting. It is possible, in other words, that Madison did indeed always support bills of rights, despite his interventions against one in the Virginia Convention. Perhaps then, also, Madison's stage of lukewarm support for the Bill of Rights overlapped with his period of opposition. Now, the best expression of his lukewarmness came in a letter to Thomas Jefferson in October of 1788. This was about 1/2 year after the Constitution achieved ratification. This letter was one in a series of exchanges between Madison and Jefferson about a Bill of Rights. Now, Jefferson was a very strong advocate for a Bill of Rights. He had said in an earlier letter to Madison, he had said, "A Bill of Rights is what the people are entitled to against every government on earth, and what no just government should refuse or rest on inference." Well, in response to this, Madison claimed, as I suggested already, to favor a Bill of Rights, but not to consider its absence to be very important. A Bill of Rights, he thought, if properly executed, could not be a disservice. That's what he said. However, he thought it could be improperly constructed, and if so, it would do harm. There were two commonly mentioned dangers that a badly drawn up Bill of Rights could bring about. The Constitution, as we all should know, as drafted, provided for a limited set of enumerated powers to be exercised by the federal government. Powers not granted were, to coin a phrase, not granted, and therefore not to be exercised. So consider a Bill of Rights provision such as in the First Amendment. Congress shall make no law abridging the freedom of speech. Now, many Federalists noted that this kind of amendment is completely unnecessary because Congress has not been granted power to abridge or even otherwise interfere with or touch on freedom of speech. So there's no need to prohibit it from doing so. And worse than the superfluity of a protection of a right Congress has no power to deal with, might not the prohibition of a power not delegated to Congress be taken to imply that there are powers beyond those actually granted to Congress? That is, might not the implication of a prohibition of a power not granted open the Constitution to an in principle unlimited array of implied powers? Thus, if a limited grant of powers to the federal government is a protection for liberty, isn't a prohibition of ungranted powers a danger to liberty? This is no doubt an irony, but it was widely feared by the Federalists and to some degree by Madison. There was also a very parallel danger with respect to rights, the sort of rights that would be protected in a Bill of Rights. Let's consider another aspect of the First Amendment. Congress shall not prohibit the free exercise of religion. This Bill of Rights provision singles out a particular right, the right of free exercise, for explicit protection. Does this not imply that rights not explicitly identified and protected in the constitutional text have no claims to protection But are there not rights that government ought not to interfere with, but which are too numerous to enumerate? What about the right to walk on the side of the street that one prefers? What about the right to save your money under your mattress or put it in the bank, whichever you prefer? Or a right to wear a hat of a style that you find attractive? Are these things merely fair game for government intrusion? Bills of rights, it was thought, can be dangerous by implying that a government has power it does not have, that is, implying powers, or by denying that there are implied rights not identified explicitly, that is, by denying implied rights. That is, it can imply powers or it can deny implied rights. Now, Madison saw these dangers as dangers, but he did not fear them as much as many others did, because he saw ways to draw up the Bill of Rights amendments so that these dangers could be avoided. His solution was ingenious: to include two additional amendments that would head off, in principle at least, the fearful consequences of a Bill of Rights. The first is what became the Ninth Amendment. That amendment reads like this: the enumeration of certain rights, that is, identifying certain rights, shall not be construed to deny or disparage others retained by the people. That is, the people have rights other than those that are expressly mentioned in a Bill of Rights. The second solution to the problems that I've just mentioned is the 10th Amendment, which reads, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. That is to say, that the protection of certain rights in a Bill of Rights is not to be taken to imply that absent that explicit protection, Congress has some sort of implied powers to otherwise abridge that right or legislate where there is no actually granted power. So Madison was able in this way to draw the poison of a Bill of Rights, but even so, during his lukewarm phase, he was not an enthusiastic supporter of a Bill of Rights. His main reservation was that a Bill of Rights would actually contribute very little to securing the rights of his countrymen. He thought that the Constitution contained plentiful instruments for the protection of liberty that was more effective than a Bill of Rights. So, for example, he saw rights protecting power in the manner in which the federal powers are granted, as he put it. That is, that the powers of the government are enumerated and limited. For the most part, the powers that are granted do not touch the topics like exercise of religion of concern to supporters of the Bill of Rights. This argument had been famously made by James Wilson of Pennsylvania, one of Madison's chief allies at the Constitutional Convention. Madison gave Wilson's argument some weight, but he also was quick to insist that he did not accept this argument in the extent argued for by Mr. Wilson. As he said in his later congressional speech on the Bill of Rights, this argument is not conclusive to the extent which has been supposed. It is true the powers of the general government, he said, are circumscribed, but even if government keeps within those limits, it has certain discretionary powers with respect to the means which may admit of abuse. So although the powers are enumerated, it might well happen that in exercising one of those powers, the legislature could choose means that impinge on a fundamental right that deserves protection. There was a common example of this at the time. Congress, we know, has a power to tax. Might it not be possible for Congress to exercise this power in such a way as to abridge the freedom of the press, as to lay a certain kind of tax on certain organs of the press? An explicit prohibition on their doing so would then add something to the limitations imposed by the enumerated powers. the enumerated character of the powers does provide some protection for rights, but not complete. More effective in protecting rights, Madison thought, is the dual structure of the new constitutional system. The combination of the limited enumerated powers allotted to Congress, along with what Madison called the jealousy of the state governments, affords, he said, a security which has not existed in the case of the state governments and exists in no other. Madison, as usual, put far more trust in institutional or structural features than in what he liked to call parchment barriers. The tensions between the general government and the states, with the latter's incentives to resist any efforts by the general government to overstep its boundaries and to abridge the rights of citizens, will apply better protection, he thought, for rights than any long list of prohibitions on governmental action. So, now all the points I have so far mentioned were more or less standard parts of the debate over a Bill of Rights. More interesting, however, was an approach to the question that was pretty much unique to Madison, the implications of which, when he thought them all the way through, led him into his third phase of enthusiastic support for adding a Bill of Rights to the Constitution. This enthusiasm was especially significant because without it, as we've already noticed, the Bill of Rights might never have become part of the Constitution, at least not in the 18th century. Now, his unique theme remained the general inefficacy of Bills of Rights, but the analysis shifted now to a more theoretical basis. Experience, he told Jefferson, proves the inefficacy of a Bill of Rights on those occasions when its control is most needed. Repeated violations of these parchment barriers, that's what he liked to call them, have been committed by overbearing majorities in every state. Now, in raising this consideration, Madison revealed how differently he was thinking of Bill of Rights, thinking about a Bill of Rights from his fellow Americans. The idea of a Bill of Rights, he pointed out, is a legacy to the Americans from their English heritage, according to which the reserved rights were intended as checks against the monarchy. In that case, Bills of Rights can have a good effect because, as Madison put it, in a monarchy, the latent force of the nation is superior to that of the sovereign, and a solemn charter of popular rights must have a great effect as a standard for rousing and uniting the superior force of the community. But the Americans had not founded a monarchy. The political dynamics, Madison pointed out, are completely different in a republic than in a monarchy. Of course, the Anti-Federalists, Jefferson, and others who favored a Bill of Rights were aware that the Constitution established a republic. But Madison's point is that they nonetheless continued to think of the danger to popular rights on the model of a monarch ruling his people. In the case of the republic, the Americans tended to believe that the danger to rights would come from acts of government contrary to the sense of its constituents. That's how he put it. Because the governors are not kept on a short enough leash, Anti-Federalists and others believed there was a constant danger that the governors would altogether slip their leash and become oppressors of the people. Madison doubted that even under this scenario, a Bill of Rights would do much good. But his general view was more than parchment was needed. Some device with teeth in it was necessary to provide an effective check and safeguard. Now here, Jefferson made a real contribution to Madison's thinking. A Bill of Rights can acquire efficacy, he thought, through the legal check which it puts into the hands of the judiciary. The courts can enforce the Constitution against errant rulers. Now, with gratitude, Madison took on board Jefferson's suggestion when when he made it an important part of the advocacy of the Bill of Rights that he produced in Congress. The judges, he said, will consider themselves in a peculiar manner the guardians of these rights. They will be an impenetrable bulwark against every assumption of power in the legislative or executive. They will naturally be led to resist every encroachment upon rights expressly stipulated for in the Constitution by the Declaration of Rights. So thanks to Jefferson, Madison had come to fully appreciate more than he had previously done the potential for good of one feature of the new Constitution, that it is a written Constitution, able to serve like other law as a basis for judicial decision. The written Constitution, called by itself in Article 6, supreme law of the land, elevates what had been mere parchment into enforceable laws. Madison had not quite appreciated that sufficiently earlier. Now, although he accepted judicial review as a potential safeguard, he was nonetheless not satisfied with it. For one thing, he had reservations about the institution of judicial review per se. He believed it to be a violation of the principles of Republican government, that is, ruled by the people, and of the separation of powers, in that it established something like judicial supremacy in a system in which judiciary was at best meant to be equal. Moreover, he did not consider judicial review likely to be fully effective when one considered the true dynamics and sources of danger to republics. As he said in one of his most telling analyses, wherever the real power in government lies, there is the danger of oppression. In our government, the real power lies in the majority of the community, and the invasion of private rights is chiefly to be apprehended not from acts of government contrary to the sense of its constituents, but from the acts in which the government is the mere instrument of the major number, i.e. the majority, of the constituents. As he had argued in his very famous Federalist Number 10 and elsewhere, republicanism did not solve the problem of tyranny. Since the majority can be tyrannous, indeed, Madison thought, is the chief threat of tyranny in a republic. A device like a Bill of Rights meant to appeal to the majority to forfend oppression imposed by a ruling elite is of no value. Moreover, since the majority was far the strongest political force in a republic, the judiciary would be limited in its ability to stand athwart it and yell, "Stop." So Madison's skepticism, lukewarmness about bills of rights was a direct result of his insights into the dynamics of Republican governance. In 1788, he was still of the view that he had held earlier, that the best check against majority tyranny was the extended republic he had defended in Federalist Number 10 and its effects on majority formation. In his letter to Jefferson, Madison laid down the maxim that had driven his earlier thinking about majority tyranny. Wherever there is an interest and a power to do wrong, wrong will generally be done, and not less readily by a powerful and interested majority than by a powerful and interested prince. Also consider the very similar thought in Federalist Number 10. If the impulse and the opportunity be allowed to coincide, we well know that neither moral nor religious motives can be relied on to provide an adequate control. In the Bill of Rights debate, he is merely adding morality and religion to those two, a list on paper of protected rights, as an inefficacious reliance for preventing oppression. And yet, despite his hesitations and his doubts about bills of rights, he became the engine that pulled that train up the hill to inclusion in the Constitution. So given his lukewarmness, it would have been extremely easy for him to have let the whole thing go in the face of a lack of real interest in Congress in pursuing it. So what accounts for the strength and the persistence of his advocacy? I think there were two reasons behind that. First, he became convinced that a Bill of Rights would cement support for the Constitution and overcome lingering doubts and suspicions about the motives of those, including himself, I should say, who had pressed hardest for the Constitution. As he said at the conclusion of his speech in Congress advocating a Bill of Rights, he said it would be highly politic for the tranquility of the public mind and the stability of the government that we should offer something in the form I have proposed to be incorporated in the system of government as a declaration of the rights of the people. He was aware that there was much suspicion in the nation that the sponsors of the Constitution were more eager to establish a strong and potentially dangerous government than to protect the rights for the sake of which governments existed. So long as such belief persisted, the people would not be wholeheartedly committed to the new Constitution, even if it was ratified. I believe, Madison said in Congress in 1789, he said that the great mass of the people who opposed the Constitution disliked it because it did not contain provision against the encroachments on particular rights. He expected that the politic adoption of the Bill of Rights would set his countrymen's hearts and minds at rest. And he seems to have been correct. Thus, Madison had his politic reasons for persisting in this Bill of Rights project. But also, and more importantly, I think, he came to think differently and more positively about the Bill of Rights itself. So what accounts for that change? In his congressional speech, Madison begins with the same basic analysis as in his letter to Jefferson. He says, the prescriptions in favor of liberty need to be leveled against the quarter where the greatest danger lies, namely, that which possesses the highest prerogative of power. But this is not found in either the executive or legislative departments of government, but in the body of the people operating by the majority against the minority. Earlier, Madison thought that this fact rendered bills of rights superfluous. But now, recognition of the dominance of the people became a reason in his mind to have a Bill of Rights. It may be thought, he said, that all paper barriers against the power of the community are too weak to be worthy of attention. Now, he doesn't say it here, but Madison, of course, was foremost amongst those who thought that paper barriers did little good. He concedes that declarations of rights may have less power than some might wish, but he now sees that these declarations have, as he put it, such a tendency to impress some degree of respect for them, to establish the public opinion in their favor, and arouse attention of the whole community. Having such a tendency, bills of rights may be one means to control the majority from those acts to which they might otherwise be inclined. The Bill of Rights, in other words, in a republic, is not, Madison now sees, a means to appeal to the people against an oppressive master, but is rather a means to educate the people not to be an oppressive master. Now, why should Madison think bills of rights can fulfill this role now, at this time, when in his letter to Jefferson, he had been rather more impressed with how little these succeed in curbing majorities? The answer lies, I believe, in his pondering the situation that he was actually facing. He was feeling the need to press for a Bill of Rights, in part because the American people wanted one. They showed themselves to be attached to the idea of special protection for their rights. Declaration of rights means something to the people. They pay attention to them. Though bills of rights are not perfect, they do rouse the attention of the whole community. And thus, as educators of the people, they can have real impact. Madison came to realize that since republicanism means that political power rests in the hands of the people, so that some effort must be made to train the people to use their power rightly and wisely. Of course, just as committed as he was to the Republican principle, he was equally wary of the tendency of republics to produce tyrannous majorities. He proposed a number of institutional solutions to this problem, the most trusted one being, as I said before, the extended republic. This device, he thought, would encourage the formation of non-tyrannical majorities. He came to see that a Bill of Rights could contribute to that same end. If republicanism means government by the great body of the people, why should the people not be formed to respect the rights their rule should secure? Why not take more seriously the idea of the people's rule and work to shape the people into a body fit to rule? Now, an explicit declaration of rights enshrined in the Constitution and enforceable by law could have an impact on the opinions of the people, so he thought. A consensus formed around the protections of the Bill of Rights is possible because the rights to be protected are almost universally demanded by all citizens for themselves and can easily be accepted as due to others as well. The people's interest in their protection of their rights differs from other interests, in that the rights interests are not, as we political scientists sometimes say, zero-sum. All can enjoy rights protections without diminishing the rights protections of others. This is normally not the case with economic interests, let's say, as involved, for example, in tax or tariff policies. Declared rights can become a political principle that the people take as a first principle of their political belief and action, as indeed has for the most part occurred with regard to the main principles of the Bill of Rights. Is there a moral to this story of the almost accidental origin of the Bill of Rights? I'll mention two here at the end of my talk. One has to do with Madison and the other with the Bill of Rights itself. As University of Georgia Professor Keith Doherty well said, a healthy controversy exists over whether Madison's policy positions remained consistent throughout his career. Shortly after the Constitution was enacted, Madison seemed to change course. Such a reversal in his politics, if true, would call into question the consistency of his political thought and challenges his role as our guide to the Constitution and the theoretical foundations of the American political system. Thus said Professor Doherty. The Bill of Rights is an obvious place where we can see Madison apparently changing his mind. But in this case, at least, we can also see that his change had more the character of his coming to accept a supplement, a Bill of Rights as educator of the people, to his fear of majority tyranny and his reliance on the institutional device of the extended republic. This is a moral, perhaps, of most interest to us scholars. A broader interest, I think, is the moral about the Bill of Rights itself. The protection of our basic rights, Madison came to see, depends not only on clever political structures, nor on the Supreme Court, but finally on us. We must hold these rights in our minds and hearts. We must assert ourselves in their defense. But Madison's point actually goes much further. These rights are not merely matters for self-assertion and self-defense, but even more for self-restraint. They are not only means to appeal to the people against an oppressive master, but even more a means to educate the people not to be an oppressive master. I thank you.
If we were all live, we would all thank Professor Zuckert, and there'd be a lot of clapping, but instead I'm just going to introduce some great questions that we already have from the audience. If you think of some more, press your Q&A buttons. The first question is from Emily Fairbend, and I'm going to paraphrase. She asks whether those who opposed the Constitution proposed any alternatives to a Bill of Rights. Was Bill of Rights their only solution, or did they have other ideas?
Now, I missed one part of what you said. Those who opposed or those who proposed the Constitution?
Those who opposed the Constitution. Did they have any other ideas other than a Bill of Rights to protect individual liberties?
Sure. Yes, they had many, many other ideas, most of which Madison wanted to avoid. The Bill of Rights was, in fact, probably not their most firmly held position. What they had in mind actually was first limiting the powers of the federal government more than they were in the Constitution as drafted. Second, how should we say, strengthening the power of the states to be involved in governance at the federal level than the Constitution as written involved. Thirdly, they wanted to increase the control of the people over the officials of the new government under the Constitution. So they had in mind, as the quotation from Herbert Storing that I read to you made clear, they had in mind many structural changes, most of which Madison and others of the Federalist Party who had supported the Constitution, most of which they were firmly set against on the ground that they would lead to the failure, once again, the failure of the American federalism, just as American federalism had failed under the pre-existing Articles of Confederation. But short answer, yes, they had quite a few other alternatives beside a Bill of Rights.
Our next question is from Ilya Winham, and he asks, is there anything revolutionary about the Bill of Rights? Or is it just an old-fashioned solution to the abuse of government power, an attempt to safeguard ancient liberties?
That's a very good question, and the answer is a sort of yes and no on that one. So there was, for example, a famous document that the English had produced at the time of their revolution, the so-called Glorious Revolution. They had produced something called, misleading or at least confusingly, the Bill of Rights. And I recently taped some lectures on the Bill of Rights in which I was constantly having to try to clarify the difference between that Bill of Rights and the Bill of Rights in the US Constitution. It gets confusing. But anyway, the idea of a Bill of Rights, it had existed prior to the American Bill of Rights. And there were bills of rights in the state constitutions as well, prior to the Bill of Rights in the US Constitution. But there is something in the US Constitution that is a bit revolutionary, and that is this aspect that Jefferson had introduced to Madison, that being the possibility of taking these not merely as, how should we say, good ideas, things that we ought to do, norms that we ought to obey, but taking them instead as actually legal provisions which could be enforced as a matter of law by courts, and which were binding on everybody in the system, including the Congress. That was a revolutionary thing. Many, should we say, innovations in political thought and the understanding of constitutions was required for the idea of a Bill of Rights to evolve from where it was in 1689 at the time of the Glorious Revolution to 1791 when we took up the Bill of Rights. So the answer is yes and no. It's a strange, odd sort of thing, but that's a lot of what was going on at that time. There was innovation going on that built on what already existed.
Ted Rosier asks, the Alien and Sedition Acts were ended through the political process. not by the courts.
Yeah.
Do you think this vindicated Madison's original position on the Bill of Rights? That maybe really they were unnecessary?
That's yeah. Again, another good, interesting question. I mean, in a way, they do. I mean, there was the political system did. You know, Madison and his fellow friend Jefferson and their party, the Republican Party, went to the country with lots of complaints about the Alien Sedition Acts. And in the election of 1800, Jefferson was elected president, and that meant the end of the Alien and Sedition Act. So they were ended by a political process. However, in the appeal by the Republicans to the country, they did use the existence of the actual Bill of Rights as one of the main grounds of argument that they could appeal to in order to challenge the legitimacy of the Alien and Sedition Acts. So although it didn't take the courts, and probably the courts would not have ended the Alien Sedition Acts given the composition of the Supreme Court at the time, but nonetheless, the Bill of Rights did play a certain part, but it played a political part, which in a way was consistent with the way Madison actually was thinking about the Bill of Rights. That is, not strictly as a legal thing, but as this thing that would become part of the, let's call it part of the political culture, something that the people would take to their hearts and would cherish, and that one could appeal to that sentiment in the people as an important protection for liberties, over and above or in addition to the appeal to the Supreme Court or other courts. So again, yeah, yes and no.
Always yes and no.
I keep saying that same thing. I know. I'm not that wishy-washy, really. But
so we have an anonymous attendee who asks a very simple question. Do you think Madison intended for the Bill of Rights to be incorporated?
That's again. There's so many good questions here. They've all been really good questions. So Madison actually, when he introduced a draft of the Bill of Rights to the Congress, he included one amendment that he thought was the most important of them all, and that amendment would provide for freedom of conscience, for trial jury, and what was the third? Now I'm forgetting what the third one was, but a third very important protection that would apply against the states. And this particular amendment was not accepted by the Senate when it considered the draft, the list of rights that would be submitted for ratification. The Senate, having been designed in a way as a more state-oriented institution, is no surprise that the Senate was less enthusiastic about that. But so Madison clearly had in mind that these protections needed to be applied against the states. So the general idea of incorporation, I mean, whether he would have incorporated the whole batch of Bill of Rights, right? I mean, I just don't know. We don't have clear evidence of that. But that there's some incorporation should occur, yes, he definitely thought that. We have very clear evidence about that. He, after that amendment went down, he complained pretty bitterly actually about it. So good. No yes and no on that one. That's just clear cut, yes.
Michael Taylor asks a question. This is, I'm going to paraphrase, but he basically wants to know how much of Madison's advocacy for the Bill of Rights was affected by his election competition against James Monroe. Did he switch positions? How much did James Monroe affect his desire to support the Bill of Rights?
Well, now this is a theory that's been voiced before. I didn't mention it in my talk. It's hard to dismiss it entirely. To give a little bit of background, the Virginia Anti-Federalists were working hard not to get Madison elected to Congress. They stood in the way of his getting a Senate seat, and then they tried to stand in the way of his getting elected to the House of Representatives. And one of the ways they did so was to encourage his neighbor, James Monroe, to run against him. And it was a pretty, pretty serious election contest between the two. And the Anti-Federalists, the Monroe was favoring the Bill of Rights, and they were, the charge was made that Madison was an opponent of the Bill of Rights, given what he had said in the Virginia ratifying convention. That was not such a stretch. And so it's sometimes said, well, that's why Madison changed his mind. I mean, I don't give that as much credit as some others do, because I see all kinds of other reasons why Madison was taking the kind of position that he did. But on the other hand, I just can't say that I don't think it hurt, you know, that that it would help him electorally if he did support a Bill of Rights. But the interesting thing is that the change that the so-called change that we see didn't really occur before, but happened after the election. So it's not clear actually that it got him that much electoral support anyway. So my view is no, but there's that was not a major force, but there's no clear definitive way to say it didn't have some impact.
So Dylan Doherty asks, we know that Madison proposed 12 amendments for the Bill of Rights rather than 10. What happened to the other 2? Why did they fail?
Why did they fail? Well, they just didn't get ratified. I guess that's the short answer. They just they just didn't get ratified. I mean, I'm not sure there's a clear, a big story to be told about that. So I'll leave it at that.
So I've got another historical question from
Okay.
Scott Ainsworth. He says, why were some rights and liberties placed in the Constitution itself? For example, habeas corpus and no bills of attainder. Why others were not placed in the Constitution itself?
Yeah, that's another good question. It's one that was raised actually at the time. One of the arguments that the that the Federalists raised in defense of not having a Bill of Rights was that, well, given the kind of government that we're setting up here, this kind of federal government, we don't need a Bill of Rights. It's not appropriate to be in this kind of constitution, and therefore we don't have one. And the rejoinder to that was, look at the Bill of Attainder provision, look at the habeas corpus provision, there weren't that many other things, but there are some, in fact, protections of rights listed in the Bill of Rights, in the Constitution itself. Why these rather than the others? Well, I'm sure that's an interesting story, the totality of which I certainly don't know. But let me speculate a little bit about at least those 2 that we've talked about so far. Both of these bills of attainder have to do with certain kinds of legislation. That is, legislation which attaints, that is, which in effect finds people guilty without the judiciary involvement. And what they're trying to say is that kind of law doesn't have a place in a separation of powers scheme of the sort that we're setting up. So it's a protection of an individual right, but it's at the same time a specific limitation on a certain sort of legislation, that this kind of legislation has no proper place. Habeas corpus is a little bit like that as well. That is, habeas corpus, the suspension of habeas corpus is not prohibited in the Constitution, but there are certain limits and conditions put on when it can be done. And you might say that's the same. That's a limitation on a power that turns out to protect rights, but in fact, to be a really major rights protector, but it's still more, say, than the First Amendment, a protection on a limitation on certain kinds of legislative action, a kind of action that's legitimate under some circumstances. We're going to specify which ones. That's, I think, the best. That's, I think, the most likely explanation for why those are included and others not.
Jane Richardson asks a nice question. She says, are there any issues or debates that arise during the Constitutional Convention or during the creation of the Bill of Rights that you're surprised we don't discuss about in school or class?
Well, the simplest answer would be, should there be a Bill of Rights at all? I mean, I think maybe that surprises us because I think we've come to take for granted that a Bill of Rights is such a crucial part of a Constitution. And as I said, is the part of the Constitution most valued by the American people. So maybe that would be the most surprising of all of the issues, whether there should be. I think surprising every time I look back at the materials that there was so little interest. If you read the debates on the Bill of Rights, you know, Madison comes up and he has to pull teeth to get them to actually be willing to spend a little time talking about a Bill of Rights. It's surprising how little there was an upswelling of interest on the part of Congress to take up that issue. So those are surprising. Some of the others, I'm not, at least at the moment, thinking of anything other than those that are particularly surprising.
So another anonymous attendee, or the same one, asks, what made the Anti-Federalists so adamant that a written Bill of Rights would protect liberties? Wasn't the revolution fought over enumerated rights that were supposed to be guaranteed, but were denied anyway?
Good. Well, I mean, in a way, the Anti-Federalists were. There was an article, a very famous article about the Anti-Federalists, written actually quite a few years ago now, maybe more than 50 years ago. Anyway, called "Men of Little Faith." Men of Little Faith. That is, the Anti-Federalists were people who always suspected that if something can go wrong, it will go wrong. You know, that old saw. And especially if government can oppress you, it will. That was their general view. And they never were that optimistic that they could with certainty head that off. But they always thought that whatever they might be able to include as an institutional or constitutional provision that might help head off oppression, put it in there. Put it in there. Never hurts to have it in there. But I don't know if any of them would go so far as to think that including a Bill of Rights would guarantee any results. They thought it would point things in the right direction. That's all I got on that one.
Sorry, my button didn't work. So Matthew Holmquist asked a question that I've always wondered, and I've never met Matthew. If the heat and crowding weren't a factor at the Constitution's drafting, do you think the Bill of Rights would have made it into the original Constitution? Did you get that, or should I repeat?
Yeah, repeat it, actually. That would be, I missed the very first part of it.
He said, if the heat and crowding weren't a factor during the Constitution's drafting in Philadelphia, I think that the rights and the Bill of Rights would have made it into the original Constitution.
That's, of course, a hard one. I mean, hypothetical history is always difficult. If they had had adequate time, if they had had, you know, not you know, taking extra time at the end of the thing, and if they had had time to actually deliberate about it, I wouldn't rule it out. But it's clear there wasn't a great upswelling of felt need that there be such a thing. So it's quite possible that if it had proven to be at all controversial and looked like it'd be time consuming, it looked like my takeaway from constructing the presidency, for example, which was from their point of view, a much bigger issue, something they had to spend a lot of time, a lot of thought on. Yeah, I can't say definitively, but I don't think it's clear that it would have been in the Constitution, actually.
So Rob Ferguson asks, what do you attribute to the continued 230-year popularity of the Bill of Rights? So the British have the Queen of England, they love her. We Americans love our Bill of Rights. Why is it continually popular after 230 years?
We love our rights. We love our rights. What more do you need to know? That seems to be it. Yeah, I think Americans see the Bill of Rights as an expression of, well, one, of guarantees of protections for them. I mean, certain things like the writ of habeas corpus, that the government just doesn't have the arbitrary right to put people in prison without legal basis. That people are free to speak freely, that people are free to practice their religion, that people can bear arms. I mean, that's a big one. These are both, I think there are two dimensions to it. On the one hand, they are protections that people value, protections against a government which could be overbearing. That's on the one hand. On the other hand, I think people take them as an expression of respect for them as free beings with dignity and the ability to govern themselves. I think that's a very important part. That we have free speech means we all get to have our opinions, we get to voice our opinions, and that they matter, and that people in government have to listen to what we say. And we've recently had this whole business about protests and so on that sometimes got a bit out of hand, for sure. But we've been reminded of how important a right it is, the right to assemble, the right to express our opinions, and so on. So I think we take it as both a protection and a sort of sign of confidence that this political system honors and respects its citizens. The Bill of Rights says that more than any other part of the Constitution.
Stephen Krug asks a more historical question. He asks, what did Madison say, or what do you think he would have said about the constitutionality of nullification and secession?
Oh, well, I know what he said about it. He said he was wrong. He did not accept nullification as a legitimate constitutional doctrine. I mean, for one thing, when he developed his plans for a new constitution at the beginning of the Constitutional Convention, trying to prevent that sort of centrifugal, that play where everything would fall apart, that's exactly what he was trying to avoid. And so nullification was really kind of an embodiment of everything that he thought the system shouldn't do, everything the system should guard against. So he certainly did not accept it as a valid part of the Constitution. I don't know if you want a kind of explanation of why Madison might have said that, but I see we're running short of time, so maybe I can point you to something another time.
So here's our last question.
Okay.
And I'm going to modify it just a little bit. And was there any significant debate about the rights included in the Bill of Rights when it was first created? Like which right include?
Yeah. Well, there was some debate. Now we're a bit hampered because the debate in the Senate is completely, we have no real records of that debate. So we don't know just what happened there. And in some ways, the debate in the Senate might have been more interesting than the debate in the House of Representatives. In the House of Representatives, there were debates about what rights and how the amendments ought to be read. However, here was a case where, again, Madison's, I'd say, political astuteness really had a big impact on the way things worked, just as he had a similar kind of impact at the Constitutional Convention. So at the Constitutional Convention, Madison came in with a worked out plan of what they should put forward as the sort of opening bid in the deliberations for a new constitution, the so-called Virginia Plan. With regard to the Bill of Rights, Madison came with a draft of what the Bill of Rights ought to be. And that draft served as the actual, the foundation for what they talked about, and tended to constrain and limit the topics that they actually considered with any seriousness. So the best defense is a good offense. I mean, Madison really realized that taking the initiative gets you very far in politics, and that was something he specialized in. This was a case of that.
So with that, I'd like to thank our audience for coming to Constitution Day this year. It's strange to do it through Zoom, but it's really a great opportunity to have Professor Zuckert here. Thank you very much.
Thank you.
I'll be the only one
Appreciate it.
clapping for.
Great set of questions. It's been great. I wish I could have seen you all, but so it goes.
Us too.
Yeah.
Thank you.
Good. So long.